In recent years, the US Supreme Court has upended reproductive rights, has loosened restrictions dramatically on guns, and has undermined the government's ability to combat climate change and solve other science and technology related concerns. In less than 2 weeks, the justices are going to reconvene as the country waits for its newest set of edicts and orders to issue. Good afternoon, and welcome to the Brennan Center live event. The Brennan Center is a nonpartisan law and policy institute that works to repair, revitalize, and defend our systems of democracy and justice so that they can work for all Americans. The Brennan Center cannot and will not support and oppose any particular candidates for office, but we will offer rigorous analysis and vigorous debate on the policies and positions that matter for our democracy. But we always do this in a civil manner. To that end, posting rude or extreme languages in our message stream is going to have you removed from the conversation. Please do follow along with the conversation on social media using the hashtag Brennan Center Live. And also there is closed captioning, live closed captioning for those who might need it. So today we've gathered together some of the Brennan Center experts at the start of this new Supreme Court term to preview what's on the docket, including some consequential cases on ghost guns and transgender rights. Also, we're looking forward to some big cases that might be lurking in the background, just not docketed yet, like those related to former President Trump's immunity from criminal prosecution and the likelihood of election-related disputes. My name is Wilfred Codrington. I'm a fellow here at the Brennan Center, and I'm the Walter Florensheimer Professor of Law at Cardozo Law School. I've been studying and thinking and writing about the Constitution and the courts for many years now, and specifically on issues related to voting and elections. And I'm going to be your moderator for today's discussion. Joining me is Michael Waldman, the president and CEO of the Brennan Center. Michael is also the author of The Supermajority, How the Supreme Court Divided America, and that book is now out on its updated paperback edition. Hi, Michael.
Hi.
We're also joined by Caroline Frederickson, who is a senior fellow at the Brennan Center, and she is the former president of the American Constitution Society. Hi, Caroline. Nice to see you.
It's good to see both of you.
Great. And it's great to have you both here. There is, and I'm talking to the audience, there's a wealth of experience and rich expertise on these matters of the Supreme Court and the decisions that they're issuing. So I don't want to delay it anymore. So I'll start with you, Michael. Your book, The Supermajority, that I mentioned, documents the ways that the Supreme Court has changed the legal landscape in the past few years. And I want to know how Americans are feeling those changes, but maybe before that question, maybe as the head of the organization named for a man who was an opponent of the death penalty, maybe you might say a few words about the court's decision last night to allow Marcellus Williams be executed in Missouri, a Black man who seems to be the character in the latest chapter of this saga of cruel and unusual miscarriages of justice, where evidence of his case seems based on shaky foundations. So that's two questions, but maybe you can have both.
Well, thank you, Wilfred. And you're exactly right, certainly. Justice Brennan was passionately opposed to the death penalty in the United States because he believed, rightly, I think, that it could be so unfairly used and that the system was so biased in its implementation. You mentioned that execution last night. That is a case where, even as I believe is the case, the prosecutors have raised questions and the family of the victim of the crime raised questions. And in fact, our country has had an execution spree in recent days. A punitive frenzy that the Supreme Court has done almost nothing to stop. The record on capital punishment cases is very, very pro execution from this court. That is only one of the areas where the court has abdicated a lot of its longstanding role uh, one would hope, as guardian of rights and guardian of the Constitution, and has moved to the right. Um, as those who are here with us today know, the Supreme Court is an institution with vast power and minimal accountability. It is susceptible to being captured, it turns out, by a faction, and it is now really in the hands of a faction of a faction. This very extreme conservative supermajority of 6 justices over the last several years has moved the court and the way it interprets the Constitution sharply to the right. And we all know cases such as Dobbs, which overturned Roe v. Wade, the Bruen case, which was by far the most sweeping Second Amendment case in history, the many cases cutting back on the ability of government to protect the environment and take other similar actions, ending affirmative action. And then this past summer, since the last term ended, basically, the really shocking decision granting significant immunity from prosecution for presidents who break the criminal law. This is a very big agenda, and now we've got this term coming up. We all like to look forward at moments like this, and we'll be discussing a number of the cases that we know about, but as you said, Wilfred, some of the most significant cases I think are likely to be ones that are not yet docketed. Cases like the next round of the Trump immunity case for his trying to overturn the election on January 6th, and whatever cases come up relating to the election. So this could be a very big term because of cases we don't even know about yet.
Yeah, and I want to get back to some of those things that we might not know about later on in the conversation. But maybe we can talk about one case, Caroline, that we do know about. Let's talk about a case that's going to impact the lives of Americans, have an outsized impact on the LGBT community. So in 2018, Tennessee passed a law restricting access to gender affirming care for folks under 18. Arguments have not been scheduled, but we know that that is docketed, that is going to be heard, and we will hear that soon. Can you tell us a little bit about that law and what's at issue there, including how the case made its way to the Supreme Court? What's at stake?
Mm-hmm. Well, there's a lot at stake. So just a little bit of background. The law SB1 of Tennessee bars doctors from providing gender-affirming medical care to minors. And that includes such things as puberty blockers, hormones, and surgeries, which have been used to allow minors to identify with or live with an identity that is inconsistent with the minor's sex assigned at birth, or to treat discomfort or distress from a discordance between the minor's sex assigned at birth and gender identity. How this proceeded to the court is that the American Civil Liberties Union and the ACLU and Lambda Legal, there was an original challenge, and the Sixth Circuit upheld the law, and the ACLU and Lambda Legal have petitioned the Supreme Court to review that ruling. And the ultimate question here is, does SB1 violate the Equal Protection Clause? And, this is quite scary because, the real question is whether if the Supreme Court, which is expected to rule by the end of June or early July of 2025, the Supreme Court could hold that the Equal Protection Clause does not prevent states from passing laws discriminating against transgender kids and adults. And so this isn't limited necessarily in its impact to gender affirming care, but actually could address other kinds of issues such as bathroom use, sports participation, health insurance plans that may not cover care for transgender people that's provided to other people, restrictions on amending birth certificates and driver's licenses to reflect a person's gender identity. And just so people know, that the ultimate issue and the question is whether or not laws that classify based on sex, such as this, are going to violate the Equal Protection Clause. The United States says that this does violate the Equal Protection Clause because it is a classification based on sex. It's subject to heightened scrutiny as a result. and it's not substantially related to achieving an important objective. So, we'll have to see where this goes, but Tennessee is, of course, arguing that this is not a classification based on sex, but it's based on age and medical condition. We could talk a lot more about this case because there's a lot at stake here. But I think just to what Michael had been saying earlier about the court's hard move to the right, the question here is whether this will be allow the court to move back from its decision in the Bostock case, which recognized that discrimination against a lesbian woman was discrimination based on sex. And Gorsuch actually wrote that decision using a textualist approach to Title VII. The question here is, will they start rolling back their what has been a not entirely inhospitable court to LGBTQ rights?
Yeah, I think that's a great summary of what's going on. I'm glad you added Bostock, that statutory case, because it seems like there's this flurry of cases, whether based on statute or the Constitution. We can go back to marriage equality. We can go back to this. We can look at Dobbs, where it just seems like there's an attack on these rights that are so personal and fundamental to one's own decision making and dignity. So the Supreme Court's not taking a break, it seems, Caroline. So thank you for summing that up for us. Another thing that the Supreme Court is not taking a break on is guns. So I want to actually talk to you, Michael, about ghost guns. You've written another book. One day I'm going to talk to you about something you've not written a book about, maybe French cuisine or something. But you've written another book, the biography of the Second Amendment. The Second Amendment has just been through it, since you wrote it in 2015. We saw the Bruen case last year, right? That was the 2022 decision, sets out this capacious text, history and tradition test to determine whether gun regulations are reasonable and permissible. Now, maybe this text, history and tradition is Baskin-Robbins' newest flavor of originalism. I don't know. We saw the U.S. versus Rahimi in June, which was an 8-1 decision in a case that clearly sets out boundaries to this test, history and tradition test, but also the court was quite fractured. Numerous decisions kind of disagreeing with each other, trying to figure out what that test actually means. And mind you, the guy who concocted the test in the dissent saying, no, you're all doing it wrong, right? So I want to talk about this ghost gun case, which is actually not a Second Amendment case, mind you, but it is important, right? I want you to tell us a little bit first, maybe about how the Second Amendment has come to be understood over time by the Supreme Court, and then maybe you can talk a bit about Van Stock.
I will unmute. You're right. It was not until 2008 that the Supreme Court ruled that the Second Amendment protected an individual right to gun ownership for self-protection. Previously, it had been understood to relate to the militia and other things. So that was a constitutional earthquake in that way. But even that case, the Heller case, said that you could have ample gun regulation, and many were upheld. That case was written by Justice Scalia, and he was asked, what's the difference between you and Justice Thomas? And Scalia said, well, I am an originalist, but I am not a nut. Well, it was Justice Thomas who wrote the Bruen decision. And you're right, that said, you effectively could not, in trying to understand whether a particular gun law passed the test of the Second Amendment, you could not consider contemporary public safety concerns, but only history and tradition, which was interpreted by many courts as being you had to find a colonial era law that was the same or almost the same as the current law being considered. It led to chaos. It led to one judge in upstate New York saying, well, history and tradition, and 2 examples of colonial era laws, that's a mere trend. For it to be a tradition, you need 3. And so therefore he said, banning guns at sleepaway summer camps in upstate New York, that was unconstitutional because they didn't have enough laws in the 1700s about it. It was a crazy ruling and a chaotic outcome. The Rahimi case last June was the court's recognition of the mess they had made. They tried to draw some lines around it. That was the case where somebody claimed he could not have his gun taken away under the Second Amendment, despite having an adjudicated record of domestic violence and restraining orders and that sort of thing. But you're right that while it in fact ruled against that individual, it didn't really clear things up much for the courts. This case, the ghost gun case, is not a Second Amendment case, but it is a gun regulation case. And it gives the court the chance, if it wants to use the other tools in its toolbox to make it harder to regulate guns in the United States. The issue is ghost guns. Those are basically like the kits that people can buy online, where you get a kit and you make your gun yourself at home. And it has no background check, it has no serial number, and all the other things that have been upheld for other kinds of gun purchases as a way to protect public safety, and that many, by far most law-abiding gun owners in this country support. This is a complete workaround, a way around it. The question is, does prohibiting ghost guns, does regulating ghost guns, is that following a statute passed by Congress? Now, the court has a cousin of originalism, which is really mostly used when they look at constitutional issues. It's called textualism. And instead of looking what the purpose of a law passed by Congress is, instead of looking at what makes sense or what's good for the country, they look at each word one at a time. They pull out dictionaries. And basically the claim here is that this regulation doesn't fit the exact wording of this law passed by Congress. Now, I will say this Supreme Court has allowed this rule by the Biden administration to stay in effect, even as they considered this case on an order in what people call the shadow docket. That's significant and might be a clue that they're not necessarily going to go full gun nut on this one. But it shows both the ways that they are, not just on this, but on all other kinds of regulatory matters, curbing the power or potentially curbing the power of experts in government agencies to do their job. And that has big implications for the environment and many other things.
Thank you, Michael. I am glad to hear at least that ghost guns were not arming paranormals and goblins at this point, but maybe that's down the road. I am afraid to hear, though, that basically what you're describing is a jigsaw puzzle. You put together this puzzle and now you're ready to go, irrespective of its ability to evade regulation. And that seems scary. Caroline, we were talking about how we can't always predict cases, right? So Dobbs was a big example. It was a household name before it overturned Roe versus Wade and Casey. It's likely, as we said, that there's going to be some significant ones that are not yet docketed. And almost certainly the justices are going to continue to see election challenges as we are now in voting season. We are actually voting in some places now. And maybe those challenges come from places that are totally inconsequential, like Arizona or Georgia or North Carolina, or these other places where we see all of these things happening. So we saw in 2020, there was these harebrained schemes to challenge Biden's victory. But what are we going to expect in 2024? Should we expect the same thing from this court? Did this last term tell us to expect something different?
Well, I have to say I'd like to be an optimist. I do prefer to be an optimist, as we all do. But in this regard, I'm very, very worried. And I think this is one where I know, Wilfred, you and Michael will want to weigh in as well, because you're both such experts on voting and elections. But let's just face the court. The court has already put its finger on the scale here, very much in favor of Donald Trump. Let's not forget how the court ensured that he stayed on the ballot and his ballot access was challenged. The rulings on the immunity case, the ruling limiting the ability to prosecute the January 6th cases, have all showed a certain direction, I think, in the court that is, if not intended to have an effect on the outcome, it's certainly will have an effect on the outcome regardless. And as we know that along the way, there are unfortunately many harebrained schemes that are already in motion. Some of them already being challenged in the courts. And one case that the Supreme Court has already addressed, coming up from the lower courts, involved a push by the Republicans in Arizona to require that all voters prove their citizenship. And the Supreme Court allowed the part of the law to go into force that requires new registrants to prove their citizenship. But they did some. This was an unsigned case, so we don't know who was necessarily on it. But on the majority that blocked the law that would have barred voters who had not documented their citizenship in the past from voting this year. The implication would have been, or the impact would have been, that people who've been registered for, who knows, decades possibly, would have had to go back, dig out their birth certificate or naturalization certificate and prove to the authorities that they were actually citizens before they could vote. And that is obviously a huge, would have a huge impact on who would vote, and it is basically a voter suppression initiative. Three of the justices, three of the conservatives, did actually say that they would have wanted that part to go into effect as well. So it's we don't really know how that who was where exactly, but it's most likely that either Chief Justice Roberts or Brett Kavanaugh were allowed part of the Arizona law to go forward, but not all of it. And part of this case that I think is important, and again, I turn to Michael Mulford, who might want to expand on this, but in this case, the court could have provided some clarification around a very, very obscure issue in voting cases called the Purcell principle. In 2006, the Supreme Court Purcell case, they gave a warning to the courts to avoid allowing last-minute changes to the status quo of voting rules before an election. But they've never really explained what is the status quo and what is last minute, and they have been incredibly inconsistent in how they've applied it. Last May, the Supreme Court invoked the Purcell principle in a case dealing with Louisiana's new congressional map that created a second majority Black district. But the three liberals dissented in that case because they were very worried that the Supreme Court was expanding this idea of the Purcell principle to moving it backwards six months before the primary. So the question is, on these cases, the court is quite inconsistent in its application. Has already indicated, that in certain of these cases that affect Donald Trump's candidacy, they have ruled in favor of him. Again, not necessarily intending to benefit him, but they have benefited him. But what really worries me is how they'll deal with these cases going forward that are going to be dealing with issues like the Arizona law, which are obviously intended to suppress votes, and yet they allowed part of that to go forward.
And Caroline, since you left that invite there for me, I will just pick up on three of your points really quickly. One is in Arizona particularly, right? This is not new to Arizona. We've seen this in Arizona. Arizona had a challenge to an earlier case about non-citizen voting that went up to the Supreme Court back in the 2010s. And so this is not new, and it's all based on this idea that is so unsubstantiated and so far from the truth that there are tons of people out here voting illegally, right? We saw that as part of the demise for a recent spending bill because there was an attempt to tack on a bill of a similar idea. So that's problematic already. Two, there's this idea going on here that, we want to keep elections from being confusing and chaotic. And that's the idea behind the Purcell principle, which sounds great, again, in theory, but is not really when we look at the details. I've recently written another piece about the Purcell principle. It's there's a short paper on the state court report. You can check that out, or there's a forthcoming piece coming out in the Washington Lee Law Review. But basically, we're starting to see this Purcell principle even more erratic, right? So now we're starting to see states invoke this Purcell principle, and they're not obliged to follow it, but they're sort of inadvertently doing so and letting it infect their own jurisprudence about elections. And that speaks to another point, which is that elections are bifurcated, right? They're between the federal and state government. Both have regulatory power over it. Congress has prevailing regulatory authority over it, so it can trump what the states say in most regards. But what the Arizona case does is it makes it so much more confusing, because you can vote for certain offices if you use a federal form, and you can vote for certain offices if you use a state form. And really, as you said, Caroline, so smartly, that this could have gone all the way back to earlier registration, where people who had registered so long ago would not be able to vote because they didn't know what form to use at what time by a rule that was not in place. I just find that to be wild. Michael, maybe you have something to say about this. Maybe it's not so wild.
Well, I think you're exactly right. The Purcell principle has some surface appeal, some logic. You don't want last minute changes because people need to be able to vote and have some certainty. Election officials need to be able to have some certainty. There's one group of people who do not have any obligation, I suppose, to abide by the Purcell principle. At least they don't think they do, which is election deniers and vote suppressors. And we've seen just in the last couple of weeks a frenzy of activity in the states where partisans trying to control the machinery of elections are trying to change the rules. Within the last week in Georgia, the rule that newly implemented that local election workers have to now count the number of ballots by hand on election night to see if they match the numbers in the machines, which will slow things down and lead to chaos. The attempt that was actually forestalled in Nebraska to change how it counts its electoral votes. All the things in all these different states, all at the last minute. The interesting question will be, well, will the Supreme Court invoke the Purcell principle and say, oh, we can't rule on this because that would be too last minute? Or will they say, no, last minute applies to everybody? And back to what Caroline said, in recent years, this has been a conservative court. This has been, one could argue, a Republican court, certainly a Federalist Society court. But until recently, it has not been a MAGA court. It has not been particularly about serving Donald Trump's electoral interests or bailing him out of accountability, legal accountability for past conduct. The immunity case and others suggested that we have lurched into new territory on this. And while in 2020, they rejected case after case, including the case where Texas sued the state of Pennsylvania, claiming that Pennsylvania had not followed Pennsylvania's election law the way the people in Texas wanted them to, the Supreme Court swatted away all these cases, including before the election, from liberals and conservatives, and then certainly the ones afterwards from Donald Trump. And I'm just not as confident. I don't know what the cases would be, but I'm not as confident that they will rule on the level this time as they did 4 years ago.
Yeah, MAGA court indeed. You know, Caroline mentioned the Colorado case, Trump versus Anderson, and the Supreme Court said that basically the states could not use the 14th Amendment to boot Donald Trump from the ballot for having aided and abetted insurrectionists. And so, you know, us court watchers were thinking maybe the court would not let that one fly. But yeah, and it didn't, right? It did not allow Colorado to boot Donald Trump from the, irrespective of what the Constitution says, from the ballot. But, you know, it went way beyond that. The court did not just stop there. It said, oh, and by the way, if this is going to be enforced, it's not just judges are going to do it. It has to be a statute of Congress. And if Congress actually adopts a statute, then we're going to give sort of review to say whether this is appropriately tailored given what the sort of threat is there. None of that stuff exists in the Constitution. That was just all made up, and it went way beyond what the scope of the question presented was. So I want to just, Michael, maybe you'll think about this. You mentioned the immunity case, right? We had the Trump versus United States case just this June, right? And that one I think did surprise court watchers. Maybe you could talk a little bit about that. What's going to stem from that? How courts are going to actually deal with the fallout from that decision?
That you're right. That did surprise so many of us. I thought I had no illusions left. Turns out I was wrong. I thought that the Colorado case, they did go too far, but I didn't think the underlying idea that one state couldn't kick a candidate off, even under that provision of the Constitution, I didn't think that was so crazy. But it seemed to me likely that there would be, in effect, they would rule that way, and they would make the legally clear, legally easy ruling that, of course, as has been understood from the beginning of the country's history, former presidents can be prosecuted for criminal activity that they engage in while in office. That, after all, was one of the main reasons why so many Republican senators did not vote to convict Trump on his second impeachment on January 6th events and his attempt to overthrow the Constitution of the United States and its peaceful transfer of power. Mitch McConnell said, well, he can always be prosecuted. That's the appropriate way to do it. So when the Supreme Court issued that ruling, it was shocking. It was a rip in the constitutional fabric. It gave vast new power to presidents to break the law. What it basically said, it had these categories of what is and is not immune. In truth, what it said is, if you're a president and you want to break the law, make sure you do it with other people who also draw a government payroll, who are also public employees. If you conspire with fellow government employees, you can say it's a public act, and you're going to basically effectively be off the hook, or almost certainly. Richard Nixon, I'm sure, speaking of ghost guns, I'm sure he wishes he'd had that ruling in his pocket. Where that could come back immediately into this court is that they remanded it, they sent it back down to Judge Chutkan to parse through the indictment that had been brought by special counsel Jack Smith for Trump's effort to overthrow the election. And they came in with new charges that were narrower, and still made the case that even things like some of the communications with Vice President Mike Pence were done by Trump as a candidate rather than Trump as president. There's going to be a submission tomorrow in Judge Chutkan's courtroom where special counsel Jack Smith is apparently going to present 180 pages of evidence that he would have presented in a trial. We won't probably know what's in that submission tomorrow. I would assume the judge will read it before releasing it, but maybe not. But sooner or later, that will all get appealed, as she has said, back up to the Supreme Court. And I think that it is certainly very possible they will hear that appeal this term. A few weeks ago, there was a startling New York Times expose by Jodi Kantor and Adam Liptak, showing that even though previous Chief Justices had worked hard to get unanimity from the court on big issues of presidential power and the rule of law, U.S. v. Nixon, among other cases, John Roberts didn't do any of that. He wrote a memo before they heard the case saying, oh, we know how this is going to go. I'm with Trump. We're all going to be with Trump. He froze out Sotomayor and Kagan and Jackson. He did not want a unanimous ruling. He wanted a ruling that would carry water for Donald Trump. So for all his pretenses of calling balls and strikes, for all his self-image as an institutionalist, which occasionally has been true, in this moment, it was quite clear he was a MAGA warrior. And that is, that is of significant concern.
Yeah, I mean, all of that with the Chutkan case, clearly judge from Florida decided to dismiss a case based on a dissent given by Justice Thomas. We have the case here, the criminal case, on hold basically for sentencing until after the election. all of that has implications from these cases, the sort of 3 cases that the Supreme Court decided in the last term, and we'll look forward to see how that all materializes. Caroline, I want to turn to you to continue, I guess, more with this sort of executive theme, and commonly, talk about what's commonly called the regulatory state, the administrative state, right? That's a very big technical sounding name for something that's really important. It's just really how government helps us to live our day-to-day lives, fighting things like climate change and artificial intelligence sort of regulations and things like that, as we can't really, deal with as they come up immediately as 3 branches of government. So this administrative regulatory state, however we call it, have these decisions changed the government sort of workings? What are we to expect after last year's, and I guess a couple years of a tear on the administrative and regulatory state?
Well, I mean, I think this is an area which, similar to the immunity ruling that Michael had been talking about, is really just explosive in terms of how we understand how our government should function, how the legislative branch and the executive branch and the judicial branch should work together, whether there should be checks and balances or whether we have a very different regime, which I think is now, the Supreme Court is supreme and they are making decisions that have very little basis in law, constitutional history or practice. This area, and I've just said, take a pause for a second on the immunity case, just because as somebody who's been teaching constitutional law at Georgetown for the past 4 years, trying to fit in the immunity case into the historical record, into the court's precedents in terms of presidential power. And it's just completely flipped everything on its head in terms of how we understand where the president can be held to account. There was at least, I think, the understanding that if the president commits a crime, and Chief Justice Burger was very focused on that in the Nixon case, which forced President Nixon to turn over the tapes to the congressional hearing, to the grand jury. That was, the reason that Chief Justice Burger said that, the president could be forced to do that was because it's a criminal case. And of course, our criminal justice system needs to work. Well, now even that has been completely undermined. And that's exactly, I think, what I'd like to say about, where we've gone in terms of what you called the regulatory state, right? Just to mention a very important principle. It's been called Chevron deference. Based on a case involving Chevron, that instituted a fairly commonsensical, a very commonsensical approach for courts to approach regulations and analyzing regulations. And that was, guess what? The EPA knows more than most of us, and certainly more than the Supreme Court justices, about the chemical makeup of pollutants and how best to deal with restricting them or protecting us against climate change under the laws that Congress has passed. But in this past term, in a case called Loper-Bright Enterprises versus Raimondo, the Supreme Court overturned that 40-year-old precedent, which now means that the courts, the justices, are in the position to determine whether or not the regulations make sense to them, and they're not going to defer to the experts. And this has already had a dramatic impact as we've had lower court judges who, especially those who have been picked specially by the advocates to bring their cases before, they have used this new precedent, Loper-Bright, to stop the implementation of the Biden administration's rules on overtime pay and healthcare discrimination. And is being used to challenge regulations on everything else from hidden airline fees to gun sales to abortion referrals. And this is going to continue to have a major impact. We could talk, there were a number of other cases that in the past several years that have significantly limited the federal government's abilities, including the power of the Securities and Exchange Commission to use in administrative law judges in cases, which has been a very important way of moving the docket and ensuring that financial misdeeds are appropriately constrained. So this is an area like presidential immunity, which really changes the terms of how our government operates. All of a sudden, we have a president who is above the law, and we have a court that gets to make all the decisions. We could talk about the major questions doctrine and all the other rules that the Supreme Court has created out of whole cloth. Textualism and originalism are only useful when they're useful, and when they're not useful, they're not useful. And I think that's all we can say as far as how consistently applied they are, or even if there is an ability to apply such loose kinds of doctrines in any consistent way. But the fact of the matter is that we have a court that Michael has already said it, so I'll say it again, is on the MAGA train. And these cases are just taking us down that, following on that train.
I'm hoping that train slows down a little bit. I feel like we've been on the Express for a very long time. And speaking of Express, we're running shorter on time. So I want to move to audience questions. And I had a question that was actually similar to an audience one. So I'm going to ask that. So I want to talk about the Supreme Court more broadly, including these controversies that seem to be swirling around them, these ethics issues, right? We are fortunate to have both Michael and Caroline as members of the Biden Supreme Court Commission. So Caroline, let me just start with you. The court adopted a code of conduct for its members in November last year. It's an ethics code. So we're all good? Is that, that's the understanding?
Yeah, not so much. It's sort of, watch what I say, but not what I do. The Supreme Court did publish a voluntary code of conduct. It was signed by all 9 justices. But let's just start from the beginning, because it's clear that the Supreme Court didn't really mean it to accomplish very much. It says itself that the rules were necessary to dispel the public misunderstanding that somehow justices regard themselves as unrestricted by any ethics rules. Well, okay, so it was not about them, it was about us. And we were wrong, but they're putting this forward just so we can dispel this understanding. But this code, voluntary, has no enforcement mechanism. And beyond that, since the code has been issued, the news stories don't stop. And we continue to hear about, the variety of very nice vacations and gifts. Boy, I wouldn't mind sailing around the world on a luxury yacht either. Nobody has offered me that, and I wonder why. But those kinds of things just continue to come to light, as well as other kinds of ethically questionable behavior. And the fact of the matter is, it has no implementation mechanism, no enforcement mechanism, and it's subject. Each justice gets to decide for themselves whether they're complying with the rules. And we know apparently several of the justices think that nothing is seemingly unethical, and that you can't go too far in taking gifts and luxury vacations. And we could go on and on about this, because there's so many ways in which this code is deficient, but including in how it deviates from the version that the lower courts use, which is based on it tells that a judge shall disqualify him or herself where the judge's impartiality might reasonably be questioned. And the Supreme Court's version, it says a justice is presumed impartial and has an obligation to sit unless disqualified. And the language requiring disqualification is even weaker. It's a justice should. So, what we have here is basically fig leaf. Well, fig leaf might even be generous because this doesn't really cover anything. It was an attempt at CYA, but I don't think anybody has taken it very seriously. And it's clearly not making a difference in either how the court behaves or how we think about the court.
And something important to note is you said that it seems like several justices don't believe that there's any sort of binding limitation on them. Well, Justice Kagan is not among those. I believe it was at NYU recently where she's explicitly spoke about how it's possible to have some sort of body of judges, imposing some sort of constraints on them so that they're too not without constraints. Michael, another question in the audience. Yeah, go for
one
it.
sport thing, Wilfred, there, which is just to say, my friend Elia Soman who teaches at the Antonin Scalia School of Law, he and I had a debate from the Federal Society of Georgetown last year, which was actually ended up being mostly an agreement about the fact that ethics rules can and should be applied, and not only could they be enforced through a group of judges, of lower court judges, but there are actually many scholars, Elia among them, who thinks that Congress could pass a law and set up its own enforcement mechanism that would function similar to how the ethics rules governing legislative and executive branch employees function. And so I think it's important for people to know that Justice Alito in particular is really way out there when he says that the Supreme Court cannot be constrained by Congress.
Yeah, and for people who are really supposed to be concerned about the text and the history and tradition, like that's Article 3 of the Constitution is quite short. It says nothing about these sort of constraints on the Supreme Court. It says very little, right? And so we're just extrapolating on a lot of these things to ensure that we don't get to a solution to problems that we see right in front of our eyes. Michael, I want to talk to you. I guess another questioner asked a question that I wanted to ask you about, since you're also a member of the commission. Can we talk about term limits? They seem to be popular. The president has now called for them. The vice president is currently calling for them. What is going on? Are we likely to see term limits? What's the holdup? How might that work?
Well, I really think Supreme Court reform of this kind, significant reform, is an issue whose time has come. Certainly at the Brennan Center, we're working hard on it. You saw earlier the slide for the Kohlberg Center, which is a major new initiative we're doing on Supreme Court reform. The public trust in the court has plunged to the lowest level recorded in polls repeatedly. And one of the solutions that we looked at on that presidential commission that I think makes a ton of sense would be an 18-year term limit for justices of the Supreme Court. That is based on the very fundamental principle that nobody should have that much public power for too long. Something, if you want to think about it, that George Washington taught us when he, limited himself to 2 terms in office. And it's interesting because unlike so many issues that I might think are a good idea, there is a broad, bipartisan, national consensus for term limits. The most recent Fox News poll a couple of weeks ago showed 78% support for term limits, which means obviously a lot of support of majority of Republicans and independents as well as Democrats. Now, it could be done by constitutional amendment. I believe that it can be done by statute as well. And there is considerable movement toward a statute that is the kind of thing Congress could put into effect. It would be coupled optimally with a regular appointment so that the president gets to make an appointment every 2 years to drain some of the toxic divisive partisanship out of the nominations process. Despite the broad public support for this, and Carolyn has been one of the people over the years who has been talking about this and working on this, despite the broad public support, I'm under no illusion that it's going to be a big group hug on the floor of Congress when this comes up. But sooner or later, this will happen. And now, as you said, Vice President Harris has endorsed it. Democratic leaders in the House and Senate have endorsed it. Certainly, if there is an alignment where the Democrats control all 3 branches, there will be a lot of progress on this. But even beyond that, this is one of the more genuinely, when you look at the country, as opposed to maybe to the politicians, one of the more genuinely bipartisan, cross-ideological bills or ideas that I can remember seeing. I think it'll happen, sooner or later.
Yeah, and again, for our listeners, Article 3, which governs the judiciary, is very, very terse. I encourage you to read it. There's not that much there, so a lot of what we're talking about is, it's coming from somewhere else. And you can, use your judgment about these questions. But as we talk about the statutory option for term limits, what why won't Congress just challenge the court? Let the court sit in the awkward position of trying to strike down term limits on itself as imposed by another branch, a co-equal branch of government. Is that a world that we should expect?
Well, people say, oh, if it's done by statute, well, the Supreme Court will just strike it down. Part of me wants to say, oh yeah, let me see them do that. If the public actually pushes Congress to do this, and Congress actually passes it, and then it gets struck down by the Supreme Court, that's a constitutional crisis, and you would get a constitutional amendment, a topic you've written an excellent book on, the People's Constitution. But also, as somebody was mentioning to me earlier today, it's hard to entirely envision who would even have standing to challenge something like that. In other words, say a president makes an appointment for an 18-year term. Are they going to kick their colleague off the bench, or do you have to wait 18 years? So it's not so clear that the justices would block it. They might do what the Supreme Court has often done in the face of political challenges, which is to back down. This kind of fight over the court, over its nature, over its structure, over, in this case, its extremism, this is not transgressive, and it's not new. It's what we've been fighting about from the beginning of the country's history. And it's entirely appropriate for the Supreme Court itself to be a major issue.
And remember, all states have some limitations on their apex court justices, right? They all have something, whether they age out and have to mandatorily retire, whether they have to run for retention elections, whether they're just capped out at a certain number of years. Every state besides Rhode Island, and Rhode Island has a very sort of thorn in your side sort of role in U.S. history, I can tell you. Every state has these sort of limitations, and it just doesn't seem right that in this era where people are living longer and longer and longer, and elections are being won/not won by majority sort of popularity, why we wouldn't want to put these sort of limitations on a court that has just exceeded the wildest imaginations of the framers. I do have to make this the final question because we are running short. So Michael and Caroline, I want to thank you again, but all of these things we talked about, presidential immunity, abortion, guns, the administrative and regulatory state, what do we make of this? What do you have to tell our audience? If you have one last thing to tell them when we leave this afternoon, what do you say?
So I'm happy to jump in. I'm sure Michael will have the most beautiful closing statement. So I will let that be the end. But I just to say, I think people need to recognize that as terrible. It can be such a downer to talk about the Supreme Court. But let's remember, the power is in our hands. That the court itself is not completely unconstrained by politics. The appointments that are made by presidents and Congress, by the Senate in particular, but the rules about governing the Supreme Court itself, the reforms that can be implemented, can be done by Congress. And we can't give up, and we can't feel like we're powerless just because the Supreme Court wants to say that it is all powerful.
Michael, anything about judicial supremacy?
Well, you're right, Wilfred, that the part of the Constitution that deals with the Supreme Court and the federal courts is only 1/10 the length of the parts dealing with Congress and the presidency, the democratically accountable and chosen branches. We, the people who wrote the Constitution, expected that the power would above all reside in the hands of we, the people. And the Supreme Court over the years, over the decades, has assumed a role of supremacy, but it forfeits that if it's seen as extreme or corrupt or out of touch. That's, I think, a moment we're in right now. This is the apex of public power. Voting has already started, as was said. What all of us can do is ask the candidates, ask the elected officials, what are you going to do about the Supreme Court? What kind of justices do you think should be on it? Will you support reforms like term limits, which is so broadly supported, or ethics reforms? We want to make the issue of Supreme Court reform at the center of public debate, where it already is in the hearts of the public. Let's make sure that it's not just something people think about, but vote about, and then a governing issue going forward.
Yeah, we want to make sure people are thinking about this and voting about this, so the Supreme Court continues to think about this before they take away any more of our cherished rights. Well, this has been a really great discussion, Michael and Caroline. Our time has come to end this. I want to thank the audience for tuning in and for participating with all of your questions. The Brennan Center looks forward to seeing you at future events. You can be the first to know when these events are announced. You can sign up for these events on the Brennan newsletter at brennancenter.org/events. My name is Wilfred Codrington. I am a fellow at the Brennan Center and the Walter Florensheimer Professor of Constitutional Law at Cardozo Law School. It has been my pleasure to have this discussion with you. Thank you for attending and have a wonderful day.